Welcome, everyone. We're going to go ahead and get started on this right away, as this is a complex topic and a lot of material to cover. For those of you who may not know me already, I'm Charlie Metzig, Managing Partner at Boyum and Barenscheer here. I'm pleased to introduce James Olney from USI, who will be leading us through today's webinar. USI is an industry leader with employee benefits, property casualty, personal risk, retirement plan needs, and they serve about 500,000 clients nationwide. And on a more local scale, they work with us, Boyum and Barenscheer, helping us with employee benefit guidance and brokerage services. James is a senior president or senior vice president and lead employment attorney who has been with USI for over 26 years. He's also an expert in state paid leave laws and programs. So we're very fortunate to have him with us for about this hour to talk about Minnesota's new paid family medical leave that will be going into effect January 1st of 2026. For everyone joining us today, and as one of our clients and as an employer, we're glad to offer you this webinar to help you navigate the upcoming deadlines and obligations, knowing that we're always willing to go an extra mile to help you with your success. With that, James, I'm going to turn it over to you to share your expertise. James, thanks for taking the time in your busy schedule, and the floor is yours.
Excellent. Thank you, Charlie. So a couple things by way of introduction. As was mentioned, I've been in the current job that I have for 26 years. When you can measure your tenure in a position in quarter century or century marks, that means you're both old and have been doing something for a very long time. Both of those things are true about me, as it turns out. Prior to taking this job in 1999, I was in private practice as a plaintiff's attorney. So my job would be to sue people like yourselves for making mistakes about laws like this. But since that time, I've been doing something quite opposite of that. I'll talk about that briefly on the next slide. As an overview to this particular presentation, couple bookkeeping things. So we've got about an hour or so to spend together. I suspect that some of you may have a lot of questions. I'm going to try, we've got a lot of materials to get through, which will answer a lot of those questions, so that's a good thing. But I also recognize that if an hour may not be enough time to capture everything. So I'll stick around after the hour is over and keep answering questions as long as you guys wish to continue to have me do so. I understand some of you may have a hard stop at 11, so be it. But point being, for those who do wish to ask questions, if we need to go past 11, we can certainly do so. You can also pop questions into the chat function. I'll try to keep an idle eye on that as the course of the presentation goes on. But once we get to the end of it, questions in the chat, or you can unmute yourself and ask questions if the system will allow you to do that. Next thing I'll say, PFML is a very big deal for a whole bunch of reasons, all of which I'll explain. You guys know that. If you didn't know that, you wouldn't be part of this presentation today, so I'm not telling you anything you don't know. But the deadlines really are coming up very, very rapidly, and we'll go through all of those as well. Let's get then into the one quick shout out, a commercial briefly for my team, and then we're going to get into the materials. Within USI, USI is it is unique in the insurance brokerage space. It's the only agency that has a team like mine, a team of lawyers dedicated to employment law issues. Our flagship service is something called our hotline service. It's unlimited phone and email access to me and my team throughout the year. You're always dealing with an attorney every time you call or email. If you aren't working with us in that space, we'd love to partner with you. If you have any interest in doing so, scan the QR code, pop an email to the hotline, and we'd love to connect. So with that said, let's get into sort of what we're going to talk about. I'm going to go over an overview of the law, sharing a bunch of details that perhaps you haven't seen in any other sessions that you have attended, a few of which you will have seen before, but reinforcement's not a bad thing. I'm then going to talk briefly about the 2025 legislative session, and in particular, those things that didn't happen, despite a bunch of press and speculation to the contrary, and the one thing that did actually happen. And then we're going to go through sort of a compliance timeline and some considerations that you guys should be mindful of as you plan for PFML compliance going forward. So let's start with the overview itself. And I'm going to start at a sort of a not philosophical level, but kinda. So if you take a step back and think about what the PFML program is set up to be, it's a social safety net. And the reason that I mention it that way, and I share it with you guys, is because the intent of the law and the way it is written and the way it is going to be administered is with employee interests in mind. There is very little thought given to employer concerns because at the end of the day, the focus is on us as individuals, each one of you on this particular webinar, all of your employees, et cetera. What that also means then by extension is administratively, there are going to be some difficulties and frustrations that are inherent to such programs and for which there are not good employer-facing answers. So we'll get there. But let's talk just briefly about what I call sort of the three cost impacts of PFML, one of which you're already probably very familiar with because you're already looking at it, and that's the hard dollar cost of premiums. You're going to have to pay at least 50% of the premium cost for the benefits program that we're talking about here. You can't pay anything less than that. So this is an employer cost, and you can choose to share the other 50% with employees. Employees can be required to pay that. We'll talk about that later. The problem with this hard dollar cost is it's a bucket of money that doesn't exist in your budget today. So you either have to take it from somewhere else within your budget, or you've got to come up with new revenue to cover this thing. So it's a new expense as a business that you're going to have to deal with. There are two then sort of ancillary soft dollar costs that go along with PFML as well. The first of those, as if you look at your workforce, you're going to have an increased incident rate of leaves compared to previous years. That's true even if you're large enough to be covered by the Federal Family Medical Leave Act. All of you are covered by the Minnesota Parental Leave Act. The reason you'll see more leaves is because the definition of family member under PFML, which we'll talk about later, is much more expansive than the MPLA, than the FMLA, et cetera. So there are more reasons for which people can be gone, thus more people will be gone. And then the second soft dollar cost is there's going to be an increased incident or increased durational aspect to the leaves themselves. People will be gone for longer periods of time. And that's because if you take a look at, again, the Minnesota Parental Leave Act or the Federal Family Medical Leave Act, those are both leave laws, but they're unpaid leave laws. And so, it's much easier to stay out for a longer period of time if I'm getting some amount of pay. And as we're going to discuss, the amount of pay I'm getting from the state, particularly if I'm a low wage earner, is actually quite high. So the additional sort of ancillary soft dollar costs that can go along with this too. You may have some overtime costs if you have to bring staff in to cover for absent staff. You may have staffing agency fees, increased stress on coworkers who are picking up extra work for their coworkers who are absent. All those things should be in the back of your mind as you plan for what compliance looks like and what your staffing sort of efforts should entail as well. All right, let's go to actually look at the content of the law itself. And the first thing to know is it covers basically everybody. Unless you are, attending this webinar, the federal government as an employer, or your employees are covered by the Railway Labor Act, basically all employers in the state of Minnesota are going to be covered. That means all of you are definitely covered. In turn, basically all employees in covered employment are going to be covered. That is important because a lot of employer benefit plans, PTO or sick and vacation practices, those sorts of things, they're not made available to part-time employees. Or like to the Federal Family Medical Leave Act, to be covered by the law, you have to check several boxes, one of which is that you have to have worked at least 1,250 hours in the 12 months leading up to the need for leave. That's spread out over a year, a 24 and a half hour a week or so employee. So this law doesn't make those distinctions. It doesn't matter whether you're full-time, part-time, casual, temporary, all those individuals are covered. You as an employer are covered. There is one exception I'll get to on the next slide that is almost certainly not going to apply to anyone in this call, so I won't spend much time on it. If you have employees in multiple states, the question comes up, are any of those other employees covered? The nexus for coverage under the PFML is you have to perform physically 50% or more of your work in the state of Minnesota over the course of the year. That's the primary test. There's a secondary one that's pretty unlikely to apply to you guys, so I won't spend much time on it, but let's stick with that 50% test, for example. That's true irrespective of state of residence. So if you've got a Wisconsin resident who crosses the border to come and work in your Minnesota facility at least 50% or more of the year, that person's covered even though they're not a resident of the state of Minnesota. So just keep that in mind. It kind of tracks with unemployment. Unemployment applies a similar standard, by the way. You pay unemployment taxes to the state in which the employee performs 50% or more of their work. There is, like I said, the second example you can see on the slide, which I'm guessing most of you aren't going to see that come about, so I won't spend any time on it. The last thing I'll say before we go to the next slide, what about 100% remote employees? So let's say you're a Minnesota-based employer. All of your employees, with the exception of one, physically work in Minnesota. The one exception is somebody who's a snowbird who actually, or is not a snowbird, they've just moved to, say, Arizona or Florida or somewhere else, and they work there remotely 100% of the time. Even though that person reports into a Minneapolis or a Minnesota headquarters, even though their manager is here and they're getting guidance from here, they're not covered. It's where work is physically performed, not where you report to. All right. So the exception, seasonal employees in hospitality who work fewer than 150 days per year are not covered. Here are some examples here. Again, I doubt any of you are going to be able to check this box. It's made more complicated by the second main bullet point. Hospitality employers must have average receipts during any 6 months of the calendar year that are no more than 33% of the average receipts for the other 6 months of the year. So it's not just being in a hospitality-based employer. It's actually being a hospitality-based employer that really does have huge seasonal swings in revenue. If you think of like a ski resort, for instance, 6 months a year is probably about 90% of the revenue. The other 6 months, well, they're not completely shut down. They have some administrative operations going on, but the receipts during that period of time are definitely no more than 33% of the receipts for the other one. It's a long way of me saying, ultimately, I doubt that any of you are going to qualify, have employees are going to qualify for this particular exception, but now you know it's there. So what does the law actually provide by way of protections? And the way to think about it, and we're going to talk about both of these things, but the law provides essentially two corollary benefits or protections for employees. The first of those is job protections, job protected leave. If I am gone for a PFML covered reason, that has job protections, those absences cannot be counted against my attendance, etc. The second benefit slash protection that it provides is the wage replacement piece of it. We'll talk about that later, but it's helpful to, I think, to see it from those two perspectives, job protections and then the wage replacement benefits. The job protections go on for, and the wage replacement benefits for that matter, are up to 12 weeks for medical leave and up to a maximum of 12 weeks for family leave. So there are two separate buckets, 12 weeks of medical, 12 weeks of family. However, employees can't take 24 months of time off in a year. The maximum amount of time they can take off is 20, which is not that much shorter than 24, but there's a 20-week cap. So if I take 12 weeks of medical leave, for instance, I don't have 12 weeks of family leave remaining. I only have 8 that I can take, even though I haven't taken any family leave in the year. So nonetheless, 20 weeks collectively is a lot of time. Intermittent absences are also covered by this law. However, only up to 480 hours of that time is going to be can be used intermittently. So if you have a 40-hour-a-week employee, 40 hours times 12 weeks is 480 hours. They could use 480 hours of that time. The remaining 8 weeks of leave, if they took for something else in the year, they couldn't use intermittently. Again, very few of your employees are likely to hit that 480 threshold, so that cap is probably not going to be particularly usable. I will note that intermittent absences are also available for bonding with a child, and that is pretty notable because that's not the case with the Federal Family Medical Leave Act, and it's not a right under the Minnesota Parental Leave Act as well. So this is a change from those two laws. The other thing is employees that have a right to reinstatement to the same position or its true equivalent. That's what job protected leave means. I understand that you guys get that, but a lot of our clients seem to be confounded by the fact that somebody's coming back after 12 weeks of leave and they'll call me to say, but we've already hired the replacement. No, you haven't. You hired a placeholder who is now going to go away because your employee is coming back. So the thing is that the right to benefits, because remember, benefits and job protection, the right to benefits starts the first day that I'm employed with you. The right to job reinstatement, however, has a 90-day waiting period. I don't have a right to reinstatement until I've completed 90 days of employment with you. So I can still qualify for benefits, but I don't have job protections until I pass day 90. Very few employees are going to be hired and then promptly need PFML leave. So that 90-day window or threshold is probably not that big of a deal, but it is there. The other thing I should note, and this is true for FMLA and Minnesota Parental Leave Act as well, the job protection doesn't give me a greater right to job protections or reinstatement than I would have had if I hadn't gone out on leave at all. So if you're, shutting down an entire department or a work area, or you're having seasonal layoffs, your employee who's out on a PFML covered leave or an FMLA covered leave or whatever, they should still lose employment at the same time because they would have lost employment if they hadn't been on leave at all. So it gives people job protections. It doesn't give them super protections, ones that are greater than they would have had otherwise. And employees can't waive participation in the program. I've had a host of clients ask me, hey, we've had employees are finding out about this and we've been communicating that we're going to have them pay a portion of the premiums. And they're saying, hey, can I waive my participation in the program if you pay me an extra 50 cents or $1 an hour? You simply can't do that. It's a mandatory legal participation is legally mandatory, so you can't have people waive it. So if you have an employee that suggests that, you're going to have to say no to that. So why can I take the leave, or for what reasons can I take the leave? The things that you see here. My own serious health condition, which by the way includes work comp injuries and illnesses. I'll talk more about that later because that's very atypical. Um, for what it's worth, the definition of serious health condition is pretty similar to the federal FMLA. So if you're dealing with the FMLA today, you'll see a corollary here. So my own serious health condition, medical care related to an employee's pregnancy, which includes prenatal care, recovery from childbirth, stillbirth, or miscarriage, bonding time off, which also applies to adoption and foster care placement, family care for a family member or military family member's serious health condition, qualifying exigencies arising from a family member's military activity, active duty. Those first five things, the ones I've just read off, those have direct corollaries in the Federal Family Medical Leave Act. So if you're already needing to comply with the FMLA, these things should look familiar to you because they are. The sixth one, the one at the bottom, is something that isn't covered by the FMLA, and that's time off for the safety of employees or their family members who are the victims of domestic assault, sexual assault, or stalking. If that sounds familiar to you, that's because that's one of the reasons for which Minnesota's earned sick and safe time can be taken. So that's been baked into PFML as well. So that's the one thing that exists outside of the FMLA, but it is already an ESST covered reason. So if we pause here, looking at the things that I've just posted on this slide, if the first five are just like the FMLA, why am I suggesting that employers are going to have an increased incident rate of absences? Shouldn't it just be the same rate that you have now because the reasons are the same under the FMLA? Again, assuming you're covered. Well, no, and that's because of this. The definition of family member is very broad. The top three, spouse, child, and parent, including parents and loco parentis, those correlate with the FMLA. Everything beneath that, domestic partner, sibling, grandparent, spouse's grandparent, grandchild, son and daughter-in-law, and I'll talk about the last one at the bottom here in a second, those ones aren't covered by the FMLA. So if somebody's taking time off for their ill sibling, for instance, they're using up PFML time, but they still have a full bucket of FMLA time that sits over here because you can't tap into it because that's not a covered reason for FMLA. So this is why I'm saying there are more reasons for which people can take leave. It's because of the broad definition of family member. At the very bottom of that list, you can see, and I've got it quoted from the statute, any individual who has a relationship with the applicant that creates an expectation and reliance that the applicant care for the individual, whether or not the applicant and the individual reside together. To give you an example of this, I had a former coworker of mine. She had a college friend of hers who moved to the Twin Cities from some other state. This woman moved here because she got a job offer. She knew nobody in the Twin Cities except for my colleague Heather. But probably 3 or 4 months after she started the job, this friend of Heather's was diagnosed with cancer. Heather was the only person around who she knew. Heather accompanied her to her doctor's appointments, helped her, as she recovered from chemo. They don't have a biological relationship. They don't have a legal relationship. They don't even live together. And yet Heather would have a right under this law to take that time off with pay to be with that person for whom she's expected to provide care. So there's a lot of reasons for which people can be gone. Just recognize that. There are some notice requirements, and we're going to start first with the ones that are imposed on you as an employer. You have to do several things. Number one, you have to post a poster, both in English and if you have not employees who have English as a second language, their primary language is another one, you're probably going to have to post a poster in their language. So the state deed, the Department of Employment and Economic Development, that's the agency that handles unemployment and is responsible for paid family and medical leave. they've created a poster, which is the link is here. That poster is available in English and 3 or 4 other languages at the moment. They're going to come up, I think, with somewhere between 11 and 16 total languages. So the posters are coming. Some of them are out there. The second thing you're going to have to do is you're going to have to provide an individualized notice to employees by December 1st or within 30 days of the date of hire if they're hired after December 1st. That spells out their PFML rights. It has to be in the employee's primary language. So again, foreign languages are going to be necessary. If English is my second language, it can be provided in paper or electronic format. And the kicker is you have to get acknowledgement of receipt and maintain a record of that. In other words, kind of like with your wage theft notices that you're providing to new hires, you have to get an acknowledged receipt of that form. The English versions of the public, so the notices you have to give to employees are different if you're in the public program versus the private program. Those notices have been posted. You know what? And actually, let me share a version of this so you can see it here. Hold on, because I want to point out something within this. So hopefully you're all seeing a Word document as opposed to the slide. If you are, this is the sample notice that has been posted for the public program participation. We'll talk about public versus private program here in just a minute. So this sample notice, if we scroll down on it, there are 2 areas where you're going to have to add content. The first of those is here. So you can see that you need to inform employees of what percentage of the premiums they're going to be expected to pay. This is not a dollar amount. This is a percentage. So if you take 0.61%, so as a sidebar, remember I said there are 2 buckets, family leave and medical leave. The state has decided that of the total premiums paid, of that 0.88%, that's the rate that the state has pegged for 2026, 0.61% of that should be attributable to medical leaves and 0.27 to family because they think that's the proportionate difference in the amount of leaves that they'll see. That's more confusing than it needs to be. I'm just telling you that. Stupidly, I think the state has broken this into 2 different buckets, family and medical leave. Employees don't care what portion of their premiums go to what. And yet the state has done this. So if you're going to be covering 50% of the premiums, 0.61, that means you'll put in there 305 would go here. So 0.305. And the same thing then would go into the employee bucket, 0.305%. And then you do the same thing, divide 27.5 here. So you don't have to calculate individual dollar number amounts for employees. You're just putting in the percentage you're going to pay. And then at the end of it, you'll put down here the total that they're expected to pay. If you're having them share half of it is 0.44. Anyway, just so when you see that form, you'll need to complete that. You'll also then need to put in your information here, kind of like with the wage theft notices. Once you do that, then you get it to the employees and you get their acknowledgement. All right, let's go back to the slides. So that form is available. There's linked here in the slide. Pay stubs are going to have to be updated to reflect premium deductions and any amounts that you're covering of those premiums. So that those things will be on the pay stub. And then if you're going with a private plan versus a public program, there's a second notice that has to be provided to employees individually about that private plan, but you don't have to get acknowledged receipt for that particular notice. If you're working with a private insurance company, they should be providing you with that secondary notice. Employees, in turn, have the obligation to provide certain notices to employers at least 30 days in advance of foreseeable leaves. As soon as practicable for unforeseeable leaves or for leaves that are foreseeable but for which 30 days advance notice can't be provided. As soon as practicable, if the need for leave changes, such as the frequency of intermittent absences or the duration of the absence that's going to be necessary. You can't require employees to find a replacement to cover their absences, which is very similar to ESST. You can't do it under that law either. But you can require, just like you can with ESST, employees to follow your normal call-in and reporting procedures. And if they fail to follow those call-in and reporting procedures, and they otherwise could have, they can be subject to discipline even if the absence itself is legally protected. That same statement is true of ESST as well as FMLA, et cetera. But if you're going to do that, you have to make sure you very consistently enforce your call-in and notice procedures and protocols. Next, the state and/or the private carrier, but the state in this case has some notice requirements as well. Once they determine that an applicant's entitled to benefits, they have to send you a notice that says, hey, here's the applicant, B, this person's applied for and been approved for benefits. 3, the week the benefits commence. 4, the weekly benefit amount payable, and that's important for something I will say later. And then 5, the maximum duration of the benefits. In other words, for how long is this person going to be receiving benefits? In other words, how long are they going to be gone or absent? Um, there's also going to be an attestation that they will provide you that says, hey, confirm that the employee told you about this leave before filing a claim for benefits. If the employee didn't actually tell you about this and you're finding out about it from the state for the first time, that can actually delay the onset of benefits until you receive proper notice. So let's move past that. So those are the notices you're going to get. I think if you go with a private carrier, you'll probably get some additional notification and information as well. We'll talk about that in a few slides. So let's go to the benefits. How do the benefits work? So remember I said that you're likely to see more absences and have those absences be longer in duration. The longer in duration part of it is because of the benefit payments that people will receive. So what are those benefits? Generally, there is a 7-day qualifying event period that must take place. For any of you that are offering a short-term disability program, you're familiar with basically a waiting period before those benefits become payable. The thing that is, so that's similar, PFML is similar to like a short-term disability program. A key difference though, is that with short-term disability, whether you have a 7 or a 14-day waiting period, whatever you might have, once the benefits kick in, they kick in going forward. So they're prospectively being paid. PFML pays retroactive to day one. So once that 7-day waiting period is satisfied, benefits are approved and paid back to day one. The only reason under PFML that there isn't a 7-day waiting period requirement is for bonding with a child. Once I say, hey, I want to take time off to bond with a child, there's no waiting period. I get benefits from day one. But in most cases, that 7-day waiting period is not going to be much of won't be a big deal. People either will very likely get past it, then they get paid back to day one anyway. The benefit paid is paid at a percentage of the employee's regular wages based on their highest earning quarter over the previous 4 quarters, capped at a max that's equal to 100% of the state's average weekly wage. That average weekly wage is reset every October 1st. So starting October 1st of this year, so a few weeks ago, the state's average weekly wage was moved up to $1,423. In other words, that's the maximum payment that an employee can receive from the state. I'll talk about the formula here on the next slide. Generally, you shouldn't have to worry about calculating the benefits because that's what the state will do or your private carrier will do. That's on them. If you are thinking of self-funding and self-administering, don't, period, for a whole bunch of reasons. But anyway, so that's the basic gist to the premiums or the benefit payments. Here's the formula. So before I go through it, and there's no reason for you to pay a whole lot of attention to the formula itself because you guys will never have to apply the formula yourself. Again, the state does that or your private carrier will. But the thing about the formula you should recognize is the state is saying, and rightly so. So there are roughly 14 states or so that have programs like this. Minnesota, it has the richest benefits for the 4th lowest premium cost in the country. I'm telling you that because mathematically that does not add up. And that certainly does not seem to be sustainable long term. It's my way of saying, I think that when we talk about what the premium rates are, that it'll help to give you context as to why I think the premium rates are going to go up year over year through the state program. But this is the basic formula. The second bullet point is probably more useful for you. And that is if you want to get a sense of how it works, employees that are making, say, $30,000 a year are going to get about 90% of their regular weekly wages. That's a pretty generous benefit. If I make $42,000 a year, I'm going to get 87% of my benefits. If I make $78,000 a year, I'm going to get about 77% of my benefits. These numbers are impressive because for those of you that do have short-term disability plans through an insurance carrier, those plans usually, not always, but usually pay at about 60%. So it's not until you earn about $120,000 or $22,000 or so that the state's program will pay you at 60%. So anyone making less than around $120,000 will get more through the PFML program than they would get through a traditional short-term disability policy. And PFML covers a lot of absences that aren't covered by STD at all. The benefits when paid, the taxation of those is complicated. And it's uncertain particularly with respect to how it applies to private plans. You generally should not need to care about the taxation of the benefits because that's typically going to be handled by the state or by your private carrier. And saying that because I've gotten a ton of questions from clients, well, how are the benefits taxed? You generally shouldn't care because for the most part, you're going to have no hand in it. One slight exception, which probably isn't worth mentioning due to its complexity. At the very bottom of the slide, I'd alluded to this 1 or 2 slides ago. So again, sticking with like a short-term disability plan, short-term disability, as I mentioned before, doesn't cover work-related injuries. Workers' comp covers that, short-term disability won't. So PFML, which operates a lot like a short-term disability program, actually does cover work-related injuries. Now, the state has something posted on its employee FAQ that suggests otherwise. The state has made a mistake there. The statute very clearly says that if the amount of benefit that I would have been eligible for through the PFML program is richer or higher than the amount I'm getting through workers' comp, PFML can be used to supplement the amount that I'm getting from workers' comp. And so it is something where ultimately you probably want to have some mind about, are you going to revise your workers' compensation protocols? In addition to the first report of injury and putting the carrier on notice, we will also give information to employees about the PFML program. You may want to consider doing so because it actually benefits you to do that. At the same time, that might also benefit the employee. Your lower wage earners in particular are likely to have that sort of dual payment, work comp plus PFML. Workers' comp usually pays somewhere around 70 or 75% of someone's wages. Your lower wage earners would get more than that to the PFML program. So let's talk about your existing paid leave policies. How are you going to coordinate and how can they be coordinated with the PFML program? So if you've got a short-term disability program, which I've talked about, referenced several times, or some kind of wage continuation program, which is tantamount to a short-term disability program, the statutes say that those short-term disability and wage continuation, STD-esque type policies are going to pay second. In other words, PFML will always pay first, and then those programs can pay on top of the PFML benefit if there is a gap, which I'll explain here in a minute. So with STD, let's say you've got a traditional short-term disability program, and let's say it pays at 60%. So if that's going to be the case, what happens is employees will receive benefits first through the PFML program. And if they get 60% or more of their wages to the PFML program, which again, if they earn less than $120,000 a year, they will, then your STD shouldn't pay at all. It's only when I'm getting less than 60%, so I'm a higher wage earner, and I'm getting, say, 55% through PFML, your STD program should pay on top of that to get me to 60%. So that's typically how those things will coordinate. But let's move away from that and let's talk about sick, vacation, paid parental leave, PTO. What are you going to do with that? So you have a choice. If you want to allow those benefits to supplement, meaning pay on top of the PFML payments to make your employees whole so that they get the equivalent of 100% of their pay, X amount, X percent from the state or the private carrier, and Y amount from you to get them up to 100%, not above that, just 100%. You can do that. But if you're going to do that, you should revise your PTO or paid parental leave or other paid leave benefit program, sick vacation, to explicitly say that. Because if you don't amend your policies, then the state assumes if somebody's using sick vacation, PTO, et cetera, that should suspend PFML payments and that an entire day of PTO or whatever would be used. No employee would choose to do that if they knew they were losing a full day of PTO. I think there's merit. You don't have to do this. I think there's merit to allowing PTO, sick vacation, whatever, to supplement the PFML payments. I say that for 2 reasons. Number one, if you're paying me on top of the PFML, you're drawing down my PTO bucket. I'll just use PTO as a shorthand. You guys may have different programs, but it's easier for my conversational purposes. What that means is if I come back from 12 weeks of leave, I will have less PTO available to me to use throughout the rest of the year. So I'll be more present for the remainder of the year. So you get a benefit there. The second benefit is that if you're paying me something, because payments from the state or from a fully insured private plan, they're not coming through your payroll. You have nothing to take my insurance premiums from, which means you either have to cover those premiums and try to collect them in arrears, assuming I return to work, or to have me write you an after-tax check once a month, give me a 30-day grace period. At day 15, send me a warning letter saying I'm going to lose my insurance if I don't pay you by the day 30. And if I don't pay by day 30, you cancel retroactive the first of the month and don't offer COBRA. That's a lot of work. So instead, if you allow a supplementation, you can take the premium payments from that supplementation. You don't have to allow supplementation. I'm just saying there are reasons that it's at least worth thinking about to do so. Next, what are the costs? The premium costs. Remember, so there's that hard dollar cost. You have to pay premiums into the state or to a private carrier, cost you're not paying right now. Well, the premium costs are based on a percentage of the employee's wages up to the FICA annual maximum rounded to the nearest 1,000. So each year, like FICA is basically paying into Social Security and Medicare. And so from our wages, and then there's an employer match, FICA payments are made into those programs. However, those payments and matches are only taken from the first $176,100 of somebody's income. So if I'm earning $185,000 or $200,000, every a bit of compensation I get above that 176.1 doesn't have FICA withholdings or FICA contributions paid in connection with it. The same thing is true with PFML. It's based on that FICA threshold. Any wages above that are not factored into the premium cost. That FICA threshold, 176,100, is reset annually. So it is going to go up for 2026, but that's the number for this year. The rates will be reviewed and reset by deed to the Department of Employment and Economic Development each year by July 31st. So the rates for all of 2026 have already been set. They're coming up here in just a second. By July 31st of 2026, the rates for all of 2027 will be set and established. So given that, what is the rate for 2026? 0.88% of FICA wages, of which at least half of that, 0.44%, must be paid by you. Now, if you're a small employer that has fewer than 30 employees, there's a lower rate that applies. You only need to pay at least 0.22%, but your employees are still going to pay 0.44%. So just keep that in mind. If you're a small employer, it's a little bit different, but for the majority of you, it's 0.88, of which half is 0.44. If you go with a private plan, and that private plan's premiums are higher than 0.88. So it's say 0.92, something like that, 0.95, whatever. Employees can only be charged 0.44%, which means you're going to be eating a larger percentage of those premiums than just half, because employees can't pay more than 0.44. Conversely, if you've got a private plan quote that is lower than 0.88, and a lot of our clients have received lower quotes, which makes it definitely advantageous to use a private plan, you can't charge employees more than half of the premiums that you're being assessed. So you can't have employees pay 0.44. Let's say that, for instance, the rate you get back is 0.8 from the private carrier. Employees can only be charged 0.40%, not 0.44. So again, they can't pay more than 50%, and they also can't pay more than 0.44 if the private rates are higher than the state's rates. The premium payments are taken from after-tax wages, not from pre-tax wages. So keep that in mind. The employer portion of the premiums is not taxable as an event to the employees. Now, employers can choose to pay a part of or all of the employee portion of the premium. Very few of our clients are doing that, but you can. If you do any part of the employee portion of the premium that you cover, you have to treat that as essentially imputed income, gross somebody's wages up, and take taxes from it. Because again, those payments have to come from after-tax income, even if you're handling them yourselves. You can substitute a private plan in lieu of participating in the state program. If you can get a quote that's anything near the state rates, you really should consider going with a private plan, because it is better for you in a whole bunch of different respects. It's actually better for your employees too. But if you're going to do it, you have to make application through your paid leave administrator account. You have to set up a paid leave administrator account. If you haven't done it yet, whether you're going through the state program or a private plan, set up your paid leave administrator account now. It needs to be set up. That's the way you're going to be able to see claims, manage them, etc. So you got to set that up. If you're going to substitute a private plan, you'll do so through that paid leave administrator account. There's a link here about how to do that. You're also going to have to file an application to substitute and a fee to go along with it. That fee is you can see a sliding scale here depending on how many employees you have. It's $250 if you have fewer than 50 employees, and it goes up from there, as you can see on the slide. Deed is saying, without statutory support, that there is, if you have a private plan, there's also an annual fee that'll have to be filed going forward. That's not in the statute. The statute just says, hey, upon initial application, you got to file a filing fee. And if you make major changes to the plan, such as switching from the Hartford to Mutual of Omaha, you're going to have a new application with a new fee. But if you stay with Mutual of Omaha or Hartford or whatever, year over year, the statute doesn't say a fee should be filed, but deed is saying there's going to be. I don't know what that fee is yet. If you're going to self-fund, which some employers might, very few of our clients are doing it, but maybe you might. You're also, in addition to the filing fee, you're also going to have to file a surety bond that's equal to the equivalent of 1 year's of premiums that you would have paid into the state if you were participating in the state program. So filing fee plus surety bond, if you're going to self-fund, is one of several reasons not to self-fund. Last thing here, some benefits. I think your employee experience is going to be better with the private plan than it is through the public program. Claims turnaround times are going to be much quicker, 1 to 2 weeks versus possibly 4 or 5 weeks. There's more accessible application portals are likely to exist. It's going to be easier for your employees to ask questions. The same is true on the converse. You, as the administrator of the program, if you're working with a private carrier, you'll get an account executive assigned to you. You'll get claims approval notices will be delivered more quickly. The reporting you're going to get from the carrier is probably going to be better than what you're going to get from the state. So it's worth looking into. If you haven't gotten a quote yet, get one. The worst thing that's going to happen is it's higher than you want it to be, and so you just stick with the state program. But if it's close to or lower than the state rates, it does seem like it makes sense to do it. So give that some thought. Let's talk about the legislative session now. And this should be a fairly simple thing to do because not a whole lot happened. But going into it, and briefly coming out of it, there was a whole lot of rumors swirling about all the things that were going to happen. So here's what didn't happen. The paid family medical leave program was not repealed in its entirety. Now, there was some speculation it would be, no legitimate speculation, and lo and behold, it didn't happen. The start date was not pushed back to 2027, even though there was a lot of speculation that it would be, again, wrong. There was not an exception made for employers with fewer than 50 employees that would exempt them for participation. The FMLA has that threshold, but not Minnesota PFML. The definition of family member was not winnowed down to just align with the FMLA. The total number of weeks per year was not limited to 12 versus 20 for smaller employers. So all these things that were rumored simply didn't happen. The one thing that did happen, so in the statute, the maximum rate that the state can use for premiums right now is 0.88%, right? That's the one for 2026. The max you can get statutorily used to be 1.2%. That number was reduced all the way down to 1.1%. Between you and me and the wall, I suppose that's an employer win of sorts. But I think if the program starts to get underfunded and needs to go beyond that threshold, they'll petition the legislature, and the legislature will likely approve the change. So, but that's the change that did take place. As you can see, that's not a whole lot by way of change. Couple of deed developments here. So there are some things. Deed is actually doing a lot of stuff. If you haven't visited, and why would you if you have a real job to do? But if you haven't visited it, it is worth checking it out. There are some things going on there. The private plan substitution application process is now active. I've got the link here. If you want to have a private plan in place and up and running by January 1st of 2026, you need to get your application in on or before November 10th. If you get it in after that, you won't be able to get a private plan in place as of 1/1. You'll have to start in the public program. Positively, DEED has confirmed that you can move from the public program into a private plan quarterly throughout the year, not just 2026, but 2027, et cetera. So you have numerous times, 4 times to be specific, throughout the year during which you can move into a private plan and out of the public program. Quick pause point here. If you go from a private plan, for whatever reasons, into the public program, and I can't imagine there'll be a lot of reasons you're going to want to do that unless somehow your rates for the private plan just skyrocket and somehow the state's rates don't, which seems super unlikely to me. But if so, if you want to move from a private plan to the public program, you can do that. do basically whenever you want, but then you're locked into the public program for 3 years. In other words, you can't go back to a private plan for a full 3 years. If you go from private to public, you're stuck in public for three. Um, so just keep that in mind strategically. The deed has set up some contact centers to answer questions about PFML. I will say they have been surprisingly responsive. I'm not sure that all of their answers necessarily align with the way I would understand the statutes, but they are responsive if you have questions. They are a resource. They're accessible through the things you see here. There's also a benefit calculator that employees can use to estimate the amount of benefits they might receive. That's not something you have to share with employees, but if you want to, you can. So that is out there as well. Let's get then, by way of back end, to compliance timelines and considerations. I'm going to start at the top with some planning considerations, and then we'll do some timeline stuff, and then we'll see what questions you guys might have in the remainder of our time. So at the top of the list, where's the money going to come from that you're going to use to pay the premiums? I mean, you got to come up with it somewhere. So where's it going to come from? Are you going to take from somewhere else? Are you going to find some new revenue stream? Know where that money is going to come from. Related to that, are you going to cover any portion of the employee premiums? The reasons some employers consider doing so, maybe they're a union environment. Maybe they are a nonprofit and there's not a lot that they can do with giving people higher wages. And so they try to have a rich benefits program. So maybe they'll cover you might have some cultural reasons that you might want to consider doing so. Very, very, very few of our clients, nonprofit status notwithstanding, aren't doing that. But again, if you do so, then you're going to have to treat that coverage as a form of imputed income and gross wages up to make sure the persons you're covering are actually taxed. Will you participate in the public program, or will you go with a private plan? If you haven't received a quote, get one. Again, if it's higher than you want to pay, no skin off your teeth, just got a quote, didn't waste any of your time. If it's close to or lower, hey, maybe think about it. How will you administratively manage PFML supplementation when there is a workers' comp situation that the workers' comp recipient is receiving less in wage replacement than they would have if they gone through the PFML program? You may want to consider, if you have any kind of consistent workers' comp claims throughout the course of the years, you may want to revise your protocols for dealing with workers' comp claims. If you have a short-term disability plan in place today, will you keep it? Because PFML covers basically everything that a short-term disability plan would cover. Most of our clients are keeping their plans in place for two reasons. Number one, because PFML does cover most of the things that STD does, your STD costs go way down because it's much cheaper for the insurance carrier to provide that product to you because they're paying out a lot less. So there's that, you save money. But then secondly, if a higher wage earner does in fact suffer a PFML covered event that's also covered by STD, they're likely to get less from the state than they would have gotten through your STD program. The STD program can get them back up to that threshold. So you don't have to do so, but it's something to think about. If you have a paid parental leave benefit that you offer to employees, will you keep that in place? Or are you going to jettison it because basically the state's taking over that responsibility? Most of our clients that have paid parental leave programs are keeping them in place, but reconfiguring them, like I suggested with PTO, so that they only pay on top of what the state pays. And the reason most of our clients are doing that is because if you take a step back and think about the basic reason that employers offer paid parental leave, it's because they've determined that for cultural reasons and organizational reasons, it is a positive thing to allow new parents to receive 100% of their pay for some period of time. If you get rid of your paid parental leave program, employees are always going to get less than 100%. So if you keep it in place, but just have it supplement the PFML program, then that's actually going to cost you a lot less as well, kind of like the short-term disability savings. Again, you don't have to keep it in place. I'm just saying think through the implications, positive and negative. How will you coordinate your other leave policies, your PTO, and then other legal ones like the Minnesota Parental Leave Act, the Family Medical Leave Act, if you offer unpaid personal leave, FMLA, MPLA, all of those things can run concurrent, meaning at the same time as PFML, if the reasons for leave are covered by both laws. Take the FMLA. If I'm taking time off for my own serious health condition, that's PFML and that's FMLA. They run at the same time on top of each other. So I don't get 12 weeks of PFML and 12 weeks of FMLA. Now, I can come up with a fact scenario where they aren't going to run concurrently, but let's put that aside for now. So make sure if you're going to have them, if you want them to coordinate, make sure that they do in fact coordinate. One last thing before I get to the final question on this slide and then go to the next one. You may recall several slides back, I had employer notice obligations. You have to have a poster, you have to have an individualized notice, you have to update your pay stubs. You notice what's missing on that list? I didn't say you have to have a handbook policy specific to PFML. I think you very much should, but it's not legally required, but you really should have it. If you're going to, it should also talk about how PFML is going to coordinate with these other leave laws. And then finally, how are you going to manage just that greater incidence rate and durational aspect to absences going forward? Your workforce is going to be affected. If you're a small employer, or if have a department that is leanly staffed and somebody is gone for 12 or 20 weeks, how are you going to plan for that? Because these things will happen. People do need leave, and if they're gone for that period of time, what are you going to do to manage through that? And then the timeline perspective, and yes, I know this is small type. Hopefully you can see it well enough. Most of these things, a lot of these things are essentially in our rearview mirror in the top half of this particular table. Couple things to note about November 1st, which is coming up here in a couple of weeks. The protection from retaliation begins, even though I have no right to take leave under the law until 2026. If you know that I'm going to need leave, you can't retaliate in 2026, that would be covered. You can't retaliate against me starting this year. In other words, you can't fire me to avoid the consequence of having me take PFML. That would be retaliation. If I have a leave need that is going to qualify in 2026, I can start filing a claim for that leave need as early as November 1st of this year. I won't get anything for it until 2026, but for instance, if I'm having a baby, and let's say that I'm going to have that baby on January 1st, just to make up a number, I might in fact want to make sure I get my claim filed with either your private carrier or the state is at the earliest juncture point possible, so that there's no delay in the benefits that I receive, that it'll be processed as soon as possible. Quick pause point. I think I had this on a slide earlier, though I didn't say it. It's coming up for a lot of our clients. Any of you who have had an employee that's had a baby in 2025, they have a right to take up to 12 weeks of bonding time off for that child in 2026, even if you already gave them 12 weeks of time off for the birth of that child in 2025. So PFML, the reason is because bonding leave for PFML purposes just needs to be taken within 12 months from the date the child is born. And so if I have a baby on July 1st of 2025, I take 12 weeks of FMLA time off, or FMLA and MPLA time off. I come back to work starting 1/1 of 2026 and going through June 30th of 2026. I can take up to 12 weeks of bonding time with payoff under the PFML program. You don't have to tell your employees that, but if they get wind of it and they want to do it, you have to allow it. By December 1st, I mentioned this earlier, you need to have your poster up and you need to have those individualized notices sent out to employees with receipt acknowledged. And then January 1st is when everything else kicks into play in earnest. The benefits become payable, etc. New hires must be provided with the individualized notices, all that jazz. Your first payment, if you're going in the public program, the first payment in that public program is going to be April 30th of 2026. If you're working with a private carrier, you'll probably be paying a monthly premium amount that you work out with them. And then the last thing I'll say, and I should have said it a couple slides ago, and then we'll see if you guys have questions. The amount that I get paid by way of benefits, remember there was that complex formula. Interestingly enough, that formula is applied not just to the wages that I earn with you. Instead, it's applied to my highest quarter of wage earnings over the previous 4 completed quarters. So if I have a second job, for instance, my highest quarter of wage earnings is going to include your wages plus that second job. And so it's actually possible that I get, as much as 100% of my wages, depending on what that second job looks like and how part-time I am with you, et cetera. So again, that's not something you need to worry about because you can't control that, but just recognize there are a bunch of different variables that go into how benefits are paid and calculated. All right, that gets to the end of our time here. Then strike that, the end of my presentation. I did say that I'd stick around for as long as you guys have questions. If you do, pop them into the chat function or unmute yourself and ask the question. Charlie, is there anything else you wanted to say before we see what questions folks might have?
No, just to thank you for the presentation. It is quite a bit of detail. Thank you for the time.
Yes, you're welcome. Oh, and actually, one other thing, I should say this. Um, a PDF of the materials are available if you want them. I think Matt, whose name you see on here, he's a benefits consultant with USI. He'll say a quick thing here in a second. You can contact him for them. I'm not sure if he's going to be proactively sending them out too. Matt, do you know how that's going to work?
I think that we'll just forward the presentation to Charlie and his
Got
team
it.
and they can forward. And then
Perfect.
I just wanted to be available if there was questions because I know that you're usually taking hotline calls during the day. So I'd be happy to field any questions. That's why we had my contact. Matt Miron, again, I work with Boyum, Barenscheer, great clients, great people to work with for the benefits. So if there is questions, please direct them to me and I can coordinate with James. And we did talk about potentially having another Q&A if there is more of a need and more questions that James might be open to doing that, but we'll have to wait for him to confirm.
Got
And
it.
James and Matt, I'm not sure if you're able to see the questions, but I think we have a slim 17 right now in the queue.
That's interesting because my webinar chat has nothing in it. So I'm going to stop sharing my screen and see if that makes a difference here. Oh, here I see it's in the Q&A, not the chat. Okay. All right. So let's go with what's been posted so far. So it says for small employers, my understanding, I'm going to bring this down to this screen so I can see without craning my neck. For small employers, my understanding is that our premium costs, if everyone else wants to see these two, open up your Q&A. I'll just keep it here though. For small employers, my understanding is that our premium cost rate can be 0.22% and the employer premium rate can or needs to stay the same 0.44. This means the employer is not paying half, even though it says half is required. All of that's correct, yes. Small employers below 30, 0.22 is all you need to pay. There's an exception for you. And so that 50% rule is not applicable to small employers. In case you care why the 0.44% is still charged to employees, it's because employees are going to receive the same benefit whether they work for a small employer or whether they work for Target. And so given that, the 0.44 always has to be paid. Small employers, the cost burden was determined to be too much, and so you get to pay less, which means, yes, you're paying less than 50%. Next question, we're a staffing firm and the client dictates how long the employee's contract lasts with the job protection. If the client ends the contract when the employees leave, what is our responsibility in regards to job protection? You don't have to return somebody to a job that doesn't exist. And so what happens is if the client contract would have canceled at some point or ended at some point during this person's leave, let's say they're gone for 12 weeks, the client contract would have run through the first 4 of those weeks. At that point, the employee no longer has a job to return to. However, you should apply your normal staffing pool practices, whatever those might be. So in other words, if this employee is eligible for an assignment, at the time they're going to return from leave, great, give them that assignment. If they're not eligible for one because there wouldn't be one available, you don't have to create work that doesn't exist. We've got a couple more questions here. Let me scroll back up to the top since for deaths in October 2025, I'm guessing that's births. So births in October 2025 and adoptions occurring in 2025. If we have an employee who's having a baby in December 2025 is still on leave when the Paid Leave Act goes into effect, would they be eligible for the new benefits even though the birth happened? They definitely would. I kind of mentioned that near the end of my presentation. Yes, births in 2025 have leave rights that extend into 2026. Our payroll providers ready to show updated Minnesota info on pay stubs? They're getting there, some more quickly than others. They all should be able to do that by the time that becomes important. I think most of them are pretty close to being at that point, but I haven't done a survey of all of them, so I can't say that with absolute certainty. Next question, can you require employees to apply for the program if they're going to take leave? So let's start with that first. Yes, you can. I think if they're taking leave that's otherwise covered, you can in fact require them to apply for the program. And there's no reason they shouldn't do so, and there's no reason they truly rationally wouldn't want to do so. And then there's a parenthetical that says we pay holidays during the unpaid portion of our standard parental leave policy, but we're changing our policy to top up holidays. If they don't apply, we would directly pay full holidays. If they do apply, we directly pay only the portion unpaid by the state benefits. This is a big impact during our week-long December holiday break. Again, you can essentially make them apply for the benefit. Most people are going to want to do so anyway, so hopefully you're not going to be twisting a whole lot of arms to get there. Can STD layer on top of as a supplemental policy? How does it affect pay? What about ESST? So let's start with the STD portion of it. Like I said earlier, STD, if you keep it in place, PFML always pays first, and you can set it up so that STD only kicks in if the employee is getting less than whatever your STD pay rate happens to be. Again, most STD policies use 60%. So if I'm receiving less than 60%, your STD would kick in and get me up to 60%. Almost none of our clients are doing this, but you have a second option with STD. You could say, you know what? We want STD to always pay 60% on top of any PFML payment, even if the PFML payment's above whatever rate the 60% that STD would normally pay at. So for example, if an employee is getting 75% of pay from PFML, you could set your STD program up to pay 60% of that 25% cap. Almost none of our clients are doing it. I can't see why you'd want to do it, but you could. So what about ESST? ESST, PTO, vacation, whatever policies you have that are internal paid policies that provide pay for absences that could also be covered by PFML, you need to make that decision. Should or shouldn't they coordinate? I've suggested in the presentation, I think you should. Here's a thing though. ESST or PTO, if you're using that to cover your ESST obligations, ESST technically is something you can't make employees use. It's a choice. However, if you structure your policy language the right way, you can get what I will call a de facto mandatory ESST usage. Here's the language you'd want to have in an ESST policy or a PTO policy, and by extension, potentially a PFML policy if you're going to allow it to supplement. And what that language is it would say, ESST or PTO will automatically apply to any covered absence. However, employees not wanting it to apply must submit a written request for it not to do so, in which case the time will be unpaid and that absence will count against your attendance, even if it is for an ESST covered reason. And that's because the job protections, by the way, go along with the use of the ESST time, not just the reason for the absence. So if you have that language, no employee is going to submit a written request saying, hey, don't have the time apply. If they have to opt out of something, they very rarely do so. It is more likely they wouldn't opt in. So with the right language, I think you can get the outcome that you're looking for. So I've got here, spoke with Paychecks, they're working on it hopefully by Jan 1, which yes, definitely hopefully by Jan 1. Kind of download the slides. Again, they'll be made available, so no need to worry about that. Can small employers still apply for grants for additional staff support if you go with a private plan? I believe that they can. I don't know the process for that, but yes, I believe that is still an option. Information about that should be on the deed website. How do you find a private plan to get a quote? So Matt, for instance, Matt Myron, who does introduce himself, he can get quotes on that. If you're working with a health insurance broker, that person, that agent can probably get a quote for you too, because they typically have contacts with those private carriers. If you're not working with a broker, or if that broker says they don't, you can also go to private carriers directly. I would say though, use someone like Matt because you want somebody to actually be your intermediary and find the best rates possible. Can you change a PTO plan to require employees to use up their PTO above what would supplement them to 100% of their pay when they take PFML? Yes, again, you'll probably have to have that language about mandatory usage that I meant, or de facto mandatory usage, and you'll want to amend your policy to say that. Are the wages the state uses for PFML the wages reported to the state? Yep, it's that highest quarter of wage earnings, which also factors in all other forms of consideration. For somebody who's a fairly recent hire of yours, you don't know exactly how much they were paid through their previous employer, so that's going to impact their highest quarter of wage earnings too. But yes, the state uses the total wages reported to the state. Is there an exemption for nonprofits and or nonprofits with fewer than 5 where the employees would never be taking work comp or PFMLA type of absences or claims? It seems like the money would be paid into an account and just die away, never used. There is no exception. And as a sidebar, those 5 employees who would never be taking workers' comp or PFMLA, if somebody has a stroke, they're going to take PFMLA. If somebody has a baby, and maybe the 5 employees of the nonprofit are beyond the childbirthing years, okay, there's that. But maybe they need to care for an elderly parent. I think it is a dangerous assumption to presume that people aren't potentially going to have that need because we're all human beings after all. That's why I said it's a social safety net. But the actual answer to the question is there is no exception. And if it's never used, that money just goes away. One quick sidebar to that. So workers' comp, unemployment, short-term disability, those programs, the cost to you as a participant in those programs is influenced by the number of claims that are filed and the amount of dollars that are paid out. The more that's paid out, the more expensive it is for unemployment, for workers' comp, et cetera. PFML does not work like that. In the state program, all participants in the state program pay the same 0.88 rate, no matter whether they use it 0 or 1,000,000 times in the year. So the money doesn't go unused. Your employees just don't benefit from it. The rest of the employers in the pool will benefit from it, which is one of the factors that the state uses to determine the rates that it charges. We're a small nonprofit with no official HR department. Where do we get help for understanding if we have someone take leave, work comp situations, etc.? We want to do it right, but we just don't know who to ask, and the state doesn't always understand our questions or tells us to ask our HR department. Aha, I get it. Yes. Shout out to this is what my team does all day long. I'm not trying to generate business here. I'm just saying we are a resource. If you have any interest in partnering with us, we can do that. Our hotline service, again, is unlimited phone and email access, not only on PFML stuff, but on payroll issues, garnishments, other leave issues, performance management. If you can partner with someone like us, that's an outlet for you. If you don't have someone like us, you can go to your own attorney, but that has a real cost that goes with it. There are some, I think, HR supportive or assistive service programs out there that might be able to, for a fee, of course, because nothing's ever free, might be able to give you some guidance. So find a business partner that you trust. Again, I'm not trying to push my team, but I think we're great at what we do. That could be an option. Is the qualification of 30 employees or fewer for small employers based on covered Minnesota employees or all employees? For example, we have approximately 25 Minnesota employees and another 12 employees who don't reside or work in Minnesota for a total of 37. Are we considered a small employer? Statutorily, I would say no, but DETA said yes. It's based on the amount of employees you have, the number of employees who would be covered. So just as an example, I've got a client I was working with. They have probably 1,600 employees nationwide. They've got, I think, 12 or 17 in Minnesota. They qualify for the small employer rates, even though they are anything but a small employer. So it should be based on the total amount of employees covered by the program. I'm a single member LLC filing as a S Corp as I am self-employed. I'm about to hire my first employee. Well, I have to have a PFML premiums for myself and my employer, just my employee. So if you're set up as an S Corp, you're probably paying yourself a wage. In turn, that wage is probably generating a W-2. As a self-employed individual, you wouldn't yourself have to participate, although you could opt into the program. But once you hire an employee, you now have two people on the payroll. And even if you just had the one, you've hired somebody, you're going to, yes, have to participate in the program. And if you're getting a W-2 wage, which I'm guessing you are, that means both you and that individual are going to be now participating in the program. How should employers handle sales-based bonuses for employees that receive leave? So it depends on how that sale-based bonus program is set up. If it's based on, I'm just making up some examples because there are a multitude of ways you can have sales-based bonuses. But if the bonus is based on achieving a certain amount of sales in a quarter or a year, if I achieve that, pay me the bonus no matter how much leave I take. If the bonus is, but if the leave that I take prevents me from making enough sales to hit the target, you don't have to, guesstimate, pretend as though either I hit the numbers or I don't. If I don't hit the numbers, I don't get the bonus. So it really depends on how your bonus program is structured. Being on leave doesn't entitle me to a bonus that I otherwise didn't earn, but if I did earn the bonus, you can't use the leave to decline paying me that bonus. Next question, we've got an employee whose sister passed away 3 weeks ago and she'll be adopting her 5-year-old nephew. Will she be eligible for up to 12 weeks of PFML for child bonding? Yes, she will be eligible for up to 12 weeks. There is a chance that she could also be eligible for some medical time off if she, for instance, goes through a depressive episode in connection with her sister's passing, which is entirely possible. You don't need to tell her that, but it is possible she could get both family and medical leave if the circumstances play themselves out right. But to your superficial question, yes, she'll be able to take up to 12 weeks of paid time off to bond with that child. Next, confirm that intermittent leave would be in lieu of and not in addition to that leave. Depending, I'm a pedantic lawyer, so I read every word as written as being significantly important to what's written. If I'm reading this the right way, intermittent leave is, for those of you that are covered by the FMLA, you're already dealing with this. If I'm gone for a half day or a day, I'll get a half day or a day worth of pay for the program, and I'll lose a half day or day of my collective 12 weeks of time off that I'm otherwise eligible for. So it's not, the intermittent absence is not additive on top of the total of 12. It just means the 12 weeks I'm going to be taking is going to be spread out over a period of time that is longer than 12 continuous calendar weeks, because I'm coming to work every once in a while and leaving work on other occasions. Going back to the next question regarding 30 employees or fewer, is that 30 during the year or during the quarter? And does this law apply to faith-based nonprofits? It definitely applies to faith-based nonprofits. It applies to everybody, basically. As to the 30 during the year or the quarter, there is a formula for it, and I'm blanking on what it is. I think it is based on, I don't want to guess. There is an answer that I can't remember the answer off the top of my head. I think that information is on Indeed's website, so you can probably catch it there. I can also answer that as a follow-up if need be. Next question, you indicated that an employer cannot incentivize an employee to not accept PFML benefits. However, is an employee required to apply for PFML benefits if they're going to be out, or could they use PTO or go unpaid? So let's take a step back. Remember, there are two things that the law has: job protections and wage replacement benefits. Let's start with the wage replacement benefits first. If you don't set up your PTO policy to supplement PFML payments, because you don't have to. If you don't, and an employee chooses to use PTO, they will not receive any benefits while they're using a full day of PTO, that is. They won't receive any benefits through the PFML program because the PTO trumps the PFML because you haven't reconfigured your policy to say it pays on top. So an employee could choose to receive a full day or week or 2 weeks of PTO. That's the benefit piece of it. But let's talk about the job protection piece of it. I think you want employees to file with file a claim because you want to reduce that bucket of job. Even if they're using their own PTO, good for them. That's their choice. Again, if you don't want to have it supplement, I still think you want to make them go into the program and apply, because that's how you're going to have their bucket of job protections be reduced proportionately. So I think it's a good idea to make them do so. You don't have to, but if you don't, if I take off, say, 3 weeks of PTO, I still got 20 weeks worth of PFML time left, which is to my advantage, not to yours. So I think you can say we want you to file a claim, but if you don't care if they do or not, you don't have to make them. But that again could potentially come to your detriment. Would you discuss exceptions for small employers with lots of high wage earners? I believe we won't get the small employer lower rate for this reason, but it's unclear. Exceptions for small employers with lots of high wage earners. I don't think there really is such a thing. Ultimately, where the higher wage earner issue comes into being isn't with respect to whether you have 30 employees or not. And so it really comes into play with how much benefit is somebody going to receive. If I'm a high wage earner, if I'm making 200, 250 or whatever $1,000 a year, the percentage of my wages I'll get through the PFML program is going to be proportionally low. $1,430 or whatever it is per week, that's well below my normal weekly pay. So that's usually where the high wage earner thing winds up being an issue, is because of the amount of benefit I will or won't receive as a byproduct of that. But as a fundamental head count thing to determine what premium rates you pay, that shouldn't actually factor into it. The other thing I'll point out from a premium perspective, because the premiums are capped at, you don't take premium payments above that FICA wage ceiling, high wage earners won't impact you significantly in the premium space, because above that 176,100, you're not taking out the premiums or paying them on yourself as well. Next, as a seasonal employer that lays off employees in November and doesn't bring them back until mid-April, can they take leave and unemployment at the same time? No, they can't receive unemployment and leave at the same time. They either get the leave or they get the unemployment. So they can't have those two things be additive. Those things one cancels out the other. So if they're getting unemployment, they don't get leave. If they're getting leave benefits, they can't get the unemployment. Next question, does paid leave apply to PTO hours or sick vacation hours, or just actual hours worked? So the way that the state looks at this is, it goes again back to your highest quarter of wages in the previous 4 quarters. So whatever that is, it takes that, comes up with a weekly equivalent amount, and then that's what it applies. So if I'm going to be gone, so in other words, it's not really going to factor in holiday time or anything like that. If I'm going to be gone for a full week and my highest quarter's wage earnings is X, and that means I should be receiving, making up a number, $1,395, under the state's formula, I'm going to get that $1,395, even if it's a week in which a holiday occurs, even of which, it's a week in which I was otherwise probably going to take vacation. I'm getting that weekly amount until my leave need comes to an end. So I think that PTO and sick vacation and holiday isn't really going to play into this, except to the extent you allow PTO sick vacation as a supplement to PFML payments. Next question, if we as an employer choose to allow current PTO to supplement employee wages, and our current PTO policy requires the use of a minimum of 1 full day of PTO, can we then reduce available PTO days accordingly when PFML is over and employee returns to work? Maybe. It feels like that actually might be tantamount to retaliation, because what you're doing is, again, making up numbers. PFML pays me 75%. You're using PTO to supplement a 25% gap. So of that, full day of PTO, I'm really only using 1/4 of that. If you're actually eliminating a full day of my PTO but only paying me 1/4 of it, I can see that as being retaliatory. Now, I can't point you to chapter verse in the statute. I can't point you to D guidance that says that, but it does feel like that consequence then is, I can be seen argued as you're using that as an excuse to exhaust PTO time in a way that isn't commensurate with the way your program is set up to work. So I wouldn't suggest it, because I think it would likely be problematic. But again, I can't say here's exactly where it says that that's illegal. Next, as far as payroll is concerned, would the leave wages be considered third-party sick pay that's generating an 8922 form at the end of the year? Again, so take this in the spirit I intended. For the most part, you probably shouldn't need to care about that. The state, it's a very complex thing, the way that the benefits are going to be taxed. For federal tax purposes, family payments, so payments for family leave, are not considered to be third-party sick paid. So it's basically a 1099 income, and the state will issue a 1099. Private carriers are a whole different matter. But if it's medical leave, then the way the federal government's looking at it for federal tax purposes is that half of it is wages, not just income, but actual wages that are subject to FICA and FUTA, and the other half is not wages subject to FICA FUTA, is because that's the portion that would have been paid by the employee portion of the premiums. So it is considered to be third-party sick pay for medical, but not for family. But again, for the most part, with one limited exception, you guys shouldn't need to worry too much about that as employers. Next, what is the most employer-friendly PTO policy available? If I give someone 3 weeks annually and they take all 20 weeks of PFML, how much PTO can be managed to be used as part of this 20 weeks? That depends on what percentage of the wages are being paid for through the PFML program. If I'm getting 50% of my wages paid through PFML, then every day I'm gone, if you're supplementing with PTO, I'm losing a half day of PTO. So under that scenario, 50% of my wages coming from PFML because I'm a higher wage earner, the other half being paid by PTO. Your 3 weeks of PTO is going to be exhausted after 6 weeks of leave, because you're cutting it down by half each day. If I'm getting 75% of my wages, then that prolongs the period of time through which that 3 weeks of PTO will be drawn out, because it's being reduced by a smaller amount. So the answer there depends on what amount I'm getting paid for by the program. Next question, is a 12-week period reset on calendar year or rolling 12 months? If you're in the state program, you must use a look forward approach. So if I take leave starting on March 1st of 2026, I have 12 months in which, from that point going forward, in which I can use all of my 20 weeks of time. If you go through a private plan, you can choose all of the reasons or calculation periods that are available under the FMLA. You can use a look forward, you can use a calendar year, you can use a fiscal year, you can use a rolling look back. And most employers use a rolling look back. So if you are going through a private plan, I'd suggest sticking with a rolling look back. If you're in the public program, you just don't have a choice. We've posted here to get the copy of the presentation. Again, I think that's going to be sent out by the good folks hosting this. We're a construction company that works around the US. For a Minnesota resident that may work in Minnesota for January, but then the rest of the year work in another state, I believe it might take the premiums out of their January wages. So the coverage in the program is based, again, on 50% or more of your work being physically performed in the state. If you're not performing 50% or more of your work in the state, but you happen to be a Minnesota resident, and there's no other state in which you perform 50% or more of your work. So long as you perform some work in Minnesota, you're covered by the program, even if that's only 5% of your time. So for instance, if you're performing 5% of your work, well, let's do 20%. You're doing 20%, you're a Minnesota resident and you perform 20% of your work in Minnesota, and you perform 40% of your work in South Dakota and 40% of your work in Nebraska. Just making up stuff here. Well, there's no state in which you work 50% or more of the time physically, but because you're a Minnesota resident and you work a part of the year in Minnesota, you're now covered by the program. So if you're not sure whether somebody's going to be covered in the upcoming year, take a look at last year. What was the proportionate amount of work? Where did that shake itself out? Use that as your guidepost, unless you know for certain that somebody's geographic work scenarios are going to be materially and identifiably different in this upcoming year. Last year's your mile marker, unless you've got material changes in the upcoming year. And then there's that other formula that I just mentioned as well. Next question, are family members and self who own the business, are these people required to be part of the program, separate than something like a workers' comp policy? So business owners, family members, if you are getting W-2 wages, you are 1000% covered by the program. If you're only getting non-wage income, then you probably aren't. But the default assumption is that yes, you're covered unless you've got a compelling argument to the contrary. Most, not all, business owners and family members receive some form of W-2 wages. If so, then you're covered by the program. Next question, because we have to continue benefits, i.e. medical and dental during an absence, how can we recoup those funds from the employee? As I suggested in the session, I think the best way to do that is to have PTO supplement the PFML payments. That way you have something to take those premium payments from. Otherwise, you have to cover those premiums and collect them in arrears when they return, or go through that whole make them send a check by the first of the month. And it's an after-tax check, by the way, if they do that, because they can't run it through a cafeteria plan. If you can supplement, that takes away the concern about having to worry about the benefits. Next, minimum wage requirement. Are tips included in that calculation to ensure that employees don't fall below the minimum wage in their areas? Yes, they are, because again, those tips are typically reported to the state. And that's a good point. If you guys have minimum wage earners or people very close to that threshold who aren't getting tips to get them well past that amount, be careful, because the premium deductions can't take their wages below minimum wage. So for somebody earning minimum wage, you're going to be covered and doesn't have tip or additional income, you're going to be paying 100% of the premiums in that case, not just 50, because you can't have the premium deductions take the wages below minimum wage. Next question, and we're getting near the end, by the way, for those who are running out of steam. So there is light at the end of the tunnel. Do you have any ideas for how employers can maintain employee equity when employees reside in states other than Minnesota with no PFML in place? Yes, there are a bunch of different things you can do. Some of our clients are adopting a shadow PFML program to provide similar benefits to their non-Minnesota based employees so that there is some continuity in benefits received. There can be some amount of work that goes into that. Not a lot of our clients are doing that, but some certainly are, because they have this equity concern. Other than that, there's not much else you can do. You can have a short-term disability policy in place. You can have a paid parental leave program that only applies to people who aren't in Minnesota, or applies to both if you want. You can come up with a few practices like that, but you really have to decide, what is it that you can do. If you're going to do a shadow PFML program, I've had a bunch of clients ask about this. We think we want to do that. Can we actually charge premiums for it? I'm not sure that you can. The reason you can charge premiums for this Minnesota's PFML is because you have to give people a benefit that is entirely employee sponsored and entirely employer funded and entire employer administrated. I think taking premiums for that is you need to get a wage deduction authorization in order to do that. And even then, I think there's at least a question mark on the practice. So think about what equity actually means, because one of the flip sides to equity is employees in Minnesota are paying a premium that employees in other states are not paying, even if they're not using the program. Are business owners covered? If they're getting W-2 wages, 1000%. If they're not, probably not. Default in favor of coverage unless you're pretty confident that there isn't going to be coverage. Next question, if they won't be getting any paycheck during this absence, how will their share of the health insurance premiums get paid? Hopefully, I've answered that already. You either collect them in arrears when they return, take it from supplementary PTO, or have them write after tax checks. You're probably not going to put them on COBRA because the state says you're supposed to keep the benefits in place during this period, kind of like you would with FMLA. So, but that's a whole wonky conversation separate, but you're probably not going to do COBRA. Next, let's see here. As a seasonal employer who has only a few employees who work year round, most do not work 150 days during the year as we are seasonal. Would it be better to work with Deed or an outside firm? I think so. A couple things here. I still think if you can get a quote from a private plan that's close to or cheaper than the state program, it doesn't matter who you are as an employer. I think you're probably better off going in that direction. And I'm not slagging on Deed. I think they're going to do a fine job. I just think the overall experience will be better through a private plan, especially if it's cheaper. I would the seasonal employer piece of it, do make sure that all of those boxes are checked, that those your revenue for 6 months of the year is no more than 33% of your revenue for the other 6 months of the year. If that's not the way it works out, then you don't qualify as a seasonal employer. On top of that, if you do meet that threshold, you have to be in your employees who are going to be exempted have to be in hospitality. So I don't know what you do, but if it isn't hospitality, then you don't have a claim for it separate and apart from the revenue from throughout the course of the year. Last few questions. Will the state use payroll systems to take the contributions from employees? Can we sync this or do we manually pay the state quarterly? Right now, you're doing a quarterly wage submission to the state anyway for unemployment purposes. Same exact process. You're going to do that. The employee portion of the premiums will be paid by you. You're basically withholding it and then keeping it there until you submit them with your quarterly wage payments. If you're going through a private plan, you'll have a different relationship. But if you're going through the state, that quarterly wage payment you make to the state will include your portion of the premiums plus the employee portion of the premiums. Next, how are casual employees handled, meaning employees that don't have a set schedule and only pick up shifts as their time allows? This could be weekly or even once every 6 months. They're definitely covered by the law. The amount of benefit they're going to be eligible for will be determined by their highest quarter wage earnings. They may be a casual employee with you, but they might have a full-time job somewhere else. So they may, in fact, be eligible for a fairly rich benefit, despite the fact they get hardly any money from you in a year. But again, that doesn't have to be your concern because that cost is not going to come back and hit you ultimately because that's not the way the program works. If a pastor is only paid a housing allowance and zero for wages, do we need to set up PFML? Probably not. There hasn't been explicit guidance in this space, but if they're not getting W-2 wages, then there's an argument that they're not really an employee, and as such, that they're probably not covered by the program. But I can't point to the chapter and verse on that, but that's my suspicion. If a job contract gets cut while on leave, do they continue with paid leave or a staffing firm where the scenario could happen if the client ends the contract? Again, you can end their employment with you or whatever, the contract ends, they may still be eligible for a paid leave benefit. So you don't have to find work for them or keep them falsely in a contract that no longer exists or anything like that. Whether they continue to be eligible for the benefit is going to be driven by whether or not they continue to be disabled by whatever their situation happens to be, whether it's a family leave, a medical leave, or otherwise. So they might still get the benefit even if that contract has come to an end. You mentioned, next question, that out-of-state employees are not eligible for the benefit. Is that true even if they're paying withholding and unemployment in Minnesota? If they're paying unemployment in Minnesota, that means that they're performing 50% or more of their work in the state of Minnesota physically. If they're doing that, they're definitely covered no matter what their state of residence is. So an out-of-state employee isn't covered if they're performing less than 50% of their work physically in Minnesota throughout the course of the year. And frankly, that's pretty much true in most cases, even for Minnesota residents. But so 50%, that's the number you're typically going to want to look at. Somebody's state of residence is largely irrelevant once you get past that number. Next, if a staff member is terminated but qualifies for PFML after the termination, am I still obligated to pay it even if the termination was not related to the PFML leave? If you're in the state program, who cares? The state's paying it. You're not paying it. You don't care. So I'm being a little bit glib, but not really. If you have a private plan, the answer is actually different. So if you have a private plan, your employee that you fired, so let's say that you fire somebody on May 1st of 2026. They go out, they file for unemployment. on July 1st of 2026, after about 8 or so weeks of unemployment, they have a PFML covered situation come up. They're eligible for PFML, and it's going to come from your private plan, because they can actually recover under your private plan for up to 26 weeks after they leave employment, or until they get a new job, at which point the right to access your private plan goes away. So in the private plan case, you're paying it in a sense because it's coming from your private plan, but really the carrier is the one, the insurance company is the one that's going to be dealing with that. So you won't really yourself ever be directly paying unless you're self-funding, which is yet another reason not to self-fund these things. But yes, people can be eligible even if they've been terminated by you, because the state doesn't look at who they're employed by or the circumstances of their unemployment. It just looks at whether they've got a covered claim. Last two questions. PFML pays 75% of employees, and we supplement with PTO and pay 25%. I get that. Can we also change our policy to pay PTO above 100% so an employee is using up their PTO more quickly while on PFML? So in that scenario, the employee would actually be receiving 175% of their pay, if I'm looking at the numbers here correctly. I don't think you can do that. So there was a question earlier on that seems similar to this. Hey, can we take a whole day deduction even though we're only paying 25%? And I said, no, I think that's retaliation. In this case, they're not losing any pay, but I think the state is set up, and if memory serves, I believe there's a guidance that suggests this, that employees can't get more than 100% of their pay through a combination of PTO, STD, and state program benefits. So I don't think that's going to realistically be an option, I think is the answer there. Last question. Just to confirm, Wisconsin resident that works 100% of Minnesota is covered under this PFML? Yes. Wisconsin resident that works 75% Minnesota is covered. Wisconsin resident that works 50% is covered. Wisconsin resident that works 45% not covered. All right. Charlie, you finally get to do your real job today. We're done. First up, I'll say thanks. I'll kick it to Charlie and then we'll call it quits. Thank you all for participating in this, for asking a bunch of really good questions. I hope you found this helpful. It was a long haul. For those that stuck around, I'm glad you're able to find the time in your calendars. Charlie, say goodbye.
James, that was really impressive. Thank you. I mean, the rapid fire questions at the end, that was great. Obviously, this created a lot of demand questions. Patty will send out the presentation with your contact information afterwards, because I'm sure there are going to be many follow-up questions as we approach year end. So appreciate your time. It was very valuable. I think we all learned a lot from it. Thank you, everyone. Feel free to reach out if you have any other follow-up questions. And enjoy the Minnesota holiday of MEA this weekend.
Thanks, everyone.
Thanks.
Bye.